Hello everyone, good evening. Please confirm if you can hear me. So I'm sure I'm not talking to myself.
Yes, we can hear you.
Yes, good evening. We can hear you.
Okay, wonderful. So good evening everyone. We welcome you to today's session. I am Ogonna Annette Ondiegu and I'll be your moderator for today's session. So in JIIPCC, we always promise you a very enriching and insightful experience, and this one would not be any different. And even good news is that we have a whole lot of mentors to guide us on this learning session. So our agenda today is going to be first the mentors presentation, the mentees presentation, the feedback sessions, and then a Q&A segments where we can interact directly with our mentors. We get to ask them questions and hear what they think about it. So it's going to be, like we already said, it's going to be very insightful. So please engage and turn on your videos so see your beautiful faces. And be sure we're not talking to robots. And without further ado, we'll begin. So we're going to introduce our mentors, and we'll start by reading out their bios so we get an insight into their professional background. And the first on our list, please forgive me if I mispronounce any name. I promise to do better next time. But the first on our list is Mr. Solomon Okedara, barrister and solicitor of the Supreme Court of Nigeria. He's a practicing legal practitioner and researcher with over 14 years post-call experience and outstanding expertise in human rights, with a special bias for digital rights, including data protection and privacy, digital identity, online expressions, intellectual property, e-commerce, tech and corporate transactions, and artificial intelligence, having an unusual knack for excellence and matchless client satisfaction with a view to delivering maximal results. Armed with a peerless ability in creative legal research and analysis, delivering impressive results in review of laws, legal principles, and standards. Solomon is a partner at Solomon Okedara and Co., a firm of barristers and solicitors, and co-founded Digital Rights Lawyers Initiative, a not-for-profit NGO that focuses on promotion and protection of digital rights. Solomon is a strategic litigation lawyer with a robust interest and proven expertise in freedom of expression and digital rights litigation. He has litigated on digital rights and freedom of expression subjects in courts across Nigeria up to the Supreme Court, and he has conducted cases at the ECOWAS courts, among others. Solomon was in 2020 recognized as one of the top 50 individuals leading in legal innovations in Africa at the Africa Legal Innovation Award. Solomon currently serves as a legal researcher with Columbia University in the city of New York for the Ivy League School's Global Freedom of Expression project, where he analyzes judgment bordering on freedom of expression subjects, covering over 120 jurisdictions across the world, including United States, Europe, India, and Africa, among others. He is a 2016 Research Fellowship recipient of International Center for Not-for-Profit Law, Washington, D.C. He was specially recognized in 2017 Heroes of Human Rights by Access Now. Solomon was specially recognized as a finalist at the 2018 Global Freedom of Expression Prize of Columbia University. If that does not impress you, I do not know what next. And our next mentor, I'm just going to read out his profile. Our second mentor for today is Mr. Ridwan Badmus. He's a tech lawyer, multidisciplinary privacy professional, and CTO. His expertise extends across various specialized technology law domains, encompassing artificial intelligence, blockchain, cloud computing, and other cutting-edge technologies. Being a certified information privacy technologist with the IAPP and an esteemed One Trust Fellow of Privacy Technology, Read1 is at the forefront of translating privacy regulation into functional applications that handle users' data, a significant void he diligently fills. Furthermore, his unique position in working across numerous complex projects bridges the gap between legal and technical teams, thereby harmonizing two distinct domains in his expansive technological landscape. Ridwan's ardor for the effective implementation of privacy and security best practices is evident in his active involvement in shaping industry standards set forth by eminent organizations such as the National Institute of Standards and Technology, the Cloud Security Alliance, and the Center of Internet Security. Oh, that's a whole lot. And the next mentor, we would have a brief insight into his profile, is Mrs. Jadesola Esan. Please forgive me for mispronunciation. She's a corporate governance and She's a corporate governance and compliance professional with vast experience in legal and regulatory compliance, risk management, corporate administration, governance, and secretarial services. She's skilled in legal governance and risk advisory, contract management, data management, regulatory compliance, and secretarial practices. And last but not the least, we have Mr. Alan Ngoma as the next mentor on our list. He is a versatile professional with extensive experience in both data science and software engineering, currently excelling as a data scientist. Currently excelling as a data scientist at Lima Labs, Kenya. His role entails collaborating closely with clients to unlock the full potential of metadata, utilizing advanced data competences to extract meaningful insights and streamline processes. Prior to his current engagement, he served as a machine learning engineer at United States of America, where he specialized in developing and deploying machine learning applications tailored to project requirements. His professional journey has encompassed roles such as data scientist at Bidco Africa. Additionally, he served as a research economist at the National Treasury of Kenya, where he conducted in-depth research on economic factors, designed surveys, interpreted data, and forecasted market trends. Driven by a passion for translating data into actionable insights, he's committed to empowering businesses to make informed decisions and achieve operational excellence. Each role has contributed to his growth and expertise, and he's eager to continue making significant contributions in the field of data science and software development. And our next mentor, Mr. Emmanuel Ewere. Just a second. Okay. He's an accomplished information technology specialist with a wealth of experience in guiding clients through the intricate legal landscape of technology. With over 8 years of expertise in the field, he has been a trusted advisor on various legal matters related to information technology, including data privacy, cybersecurity, intellectual property, and e-commerce. Education has been a cornerstone of Emmanuel's professional journey. In 2015, he earned his Call to Bar certificate from the Nigerian Law School, building a solid foundation in general law. He further honed his specialization in information technology law by pursuing a master's degree from the University of Tartu in Estonia. Prior to that, he completed his Bachelor of Law at Madonna University in Nigeria. Emmanuel's career has been marked by the significant accomplishments, and he has held key roles in prestigious organizations. As a As a business developer at Flow World LLC in the United Arab Emirates, he managed various projects, ensuring compliance and due diligence. He provided crucial counsel to clients on matters such as data privacy, cybersecurity, and intellectual property. Additionally, Emmanuel's skills in drafting contracts, conducting market research, and budgeting were instrumental in driving the success of various projects. During his tenure at Adamson Adeboro SAN and Co., a prominent law firm in Nigeria, Emmanuel actively supported attorneys in legal research and document review. He played a pivotal role in drafting legal memos and reports while also engaging in client meetings and negotiation. His litigation experience was an asset in court appearances on behalf of clients. Emmanuel Aware is not just a legal expert, but also a tech-savvy professional. His technical skills include proficiency in Python and a comprehensive understanding of information technology systems and processes. He excels in risk management and compliance, crucial elements in the dynamic world of IT law. Moreover, his adeptness in contract drafting and negotiation, coupled with a solid grasp of cloud computing, IoT, and blockchain makes him a well-rounded specialist in the field. Recognizing the importance of continuous learning, Emmanuel has pursued various professional development opportunities. He holds a certification as an information privacy professional and consistently engages in continuing legal education courses that focuses on data privacy and cybersecurity law. Emmanuel actively contributes to the legal community through his affiliations. He is a member of the Nigerian Bar Association, where he actively collaborates with fellow professionals to address emerging legal issues in the tech realm. Furthermore, he is a member of the International Association of Privacy Professionals, a testament to his commitment to staying at the forefront of data privacy matters. With his impressive credentials and extensive experience, Emmanuel Ewere continues to make a significant impact in the realm of information technology law. Through his legal acumen and technical expertise, he serves as a reliable ally for clients seeking guidance in navigating the intricate legal challenges of the digital age. That's it for our mentors, and a whole round of virtual applause to them. It's a pleasure to have you with us, and it would lead us we've gotten to know them. This insight to their profile would lead us to the next agenda we have, which is mentors presentation. So we're going to call on our mentors and ask them to give us an insight into the topic we have today. So, Mr. Emmanuel, you're the first on our list. Can we begin with you? Each mentor has 20 minutes to speak. Mr. Emmanuel, you have the floor.
Hello, everyone. Just to be sure that you can all hear me, can you confirm you can hear me?
Yes, we can hear you loud and clear.
Perfect, perfect. Hi, Ugonna, and nice to meet you. And
Thank you.
hello to everyone, and let us have another exciting time together. And for today, I believe that based on the presentations that have been sent across, I will say that you guys have done justice to today's topic. But I will try and make it clearer with a Nigerian case that really gave a brighter a brighter look into the whole concept of um, the legal grounds on which data can be processed. Now I'll look at the case of the True Colors case. I saw group one, they just mentioned a bit about it, but they didn't really they didn't even get the main decision of the court. But just pay attention now to what this case is all about. Now, this case is actually, how I'll put it in a sense that this case actually exposes the complexity of safeguarding personal information and looking at Nigeria um, as a growing baby in adoption of the privacy and data protection framework and the application of the law. So in this particular case, um, a lawyer called Babalola, Olumide Babalola, and Olusakami Bello. I'll just call him Bello before I'll mispronounce that name. Okay, they brought an action against Truecaller. I believe that majority of us should know Truecaller app. In fact, if not all should know Truecaller app. That app that once you've you've downloaded it, you've installed it, and you're giving it the consent um to your contacts and your so they can actually tell you who is calling. So back to the case. Olumide and Bello, they filed a case against Truecaller, and in their case, they claim that Truecaller is infringing on the privacy rights on data subject, especially in regards to the collection, the storage, and the processing of their personal data. And in that case, they explained that based on section 37, yes, 37 of the Constitution, that Truecaller has violated the constitutional right of privacy of data subject, and they needed a declaration of the court to a perpetual injunction against Truecaller. So now this case borders very strongly on consent. And when we talk about consent, we know that consent is a fundamental ground. It is the first for the possession of personal data. So they wanted a perpetual injunction against Truecaller to stop them from processing data without explicit consent. So, in defense to this case, Truecaller contested this allegation and claimed a lot of things. In fact, the claims of Truecaller was so mind-blowing that I was just I was laughing at some point. In fact, it was so interesting to read. Their lawyer must be very, very smart. So I'll give you I'll give you tips of exactly what transpired in that case. So Truecaller contested the whole suit, and they claimed a lot of things like that those ready start callers that the ready start callers in Truecaller are not are not how will I put it? Okay, let me put it this way, that they are not the controllers, but anyone who subscribes to their app. This sounds very, should I say ambiguous? Should I say complicated? Okay, how on earth did their lawyer bring up such kind of argument? But I'll share more light on what the court decided on that. And they also argued that even those subscribing to the app, they usually give their consent because Truecaller will bring out a notice and say, do you consent to Truecaller accessing your contact? And the subscribers will say yes. And that suffices as consent. Now, I want you guys to pay attention to how the judge looked into the whole issue. The court, in her wisdom, yeah, and because quite a controversial decision though, but in her wisdom, the court dismissed the case of the plaintiff because the court stated that the plaintiff did not prove breach of privacy by Truecaller, so the court was not convinced by the argument of Babalola and Bello that Truecaller had been breaching the rights of data subjects in the collection, in the storage, and in the transfer of their data. Also, the court also agreed with Truecaller. Now, this is the catch of the whole judgment that got me really amazed. The court agreed with Truecaller that subscribers are the data controllers. How on earth did the judge get such kind of? But because I couldn't just get a grasp on why would the judge even tint towards that direction. But the judge gave an elaborate explanation and details to why he feels that why he is of the view that subscribers are the data controllers. Now, let us look critically at this very case. Now, this case, as I said from the beginning, is actually one that touches the, the complexity of safeguarding personal information and against the misuse. And looking at our topic today, the legal grounds on which data can be processed. Now, it borders on consent as well. And if you remember in our previous class, we noted the fact that consent must be explicit. Consent must be unambiguous. Consent must be made up in the language that every data subject will understand and either approve or decline to. But in this case, the court drifted to another view of the fact that the judge, in his judgment, agreed with Truecaller that subscribers are the data controller and not Truecaller, the company. Mind blowing. But something to think about. If the judge stands on the position that subscribers are the data controllers, but On another turn of the coin, Truecaller are into the procession of personal data. So the judge couldn't address the issue of Truecaller being a data processor if they are not a controller. So this also gives us an in-depth call to, to get a full knowledge on who is a data controller, because the judge has actually expanded the scope. Now, back to our today's agenda. Consent. Can we say that there is consent by the subscribers to Truecaller for the procession of their personal data? What about those that did not subscribe, but Truecaller still reveals their identity? On what position will they stand? I won't take much of our time. I believe that we will come back to this issue and we will use this case to build more on this very issue of consent. And from our last class, we were able to understand the various parties in this whole privacy and data protection. We know of a sure that there is a data subject. That is the main focus. We know that there is a data controller. We know that there is a data processor. We know that there is a third party. I will give room for other mentors to also share knowledge about today's topic. Thank you very much. Thank you,
Thank you so
Ugonda.
much, Emmanuel. We are grateful for that very, very wonderful presentation. I learned a lot. I was actually jotting, and we are, while waiting for the mentors, we're just going to go ahead with the mentees presentation. Mentees, I'm sure you have your presentation ready. And each of you have just 7 minutes to present yours. So it will be followed by feedback by our mentor. So group 1, let's proceed.
Please, can we have the group presenter for group 1? If group 1 is ready, please.
Good afternoon. I'm here.
Oh, all right.
Okay.
Please go ahead. You have 7 minutes.
I'm sorry, I'm trying to share my screen. Can you see it now?
Yes, we can.
Oh, okay. So good afternoon, everyone. I'm Esther Nkechinyere Odunze, and I'm going to be presenting on behalf of Group 1 on data collection, processing, and transfer, the best practices, types of data, their sensitivity level, and the concept of data minimization. So you most likely have heard that data is one of the most valuable assets. Like when they say data protection, privacy, it's no longer just the words you hear everywhere. There are actually things that pertain to us. A lot of companies, in fact, all businesses find them very, very valuable. And while in the process of collecting this data, in processing it, in transferring it, there are a lot of considerations that companies or data processors and controllers now must put into consideration. And that's what this presentation would be about: the best practices for data collection, for processing it, for its transfer, that's in a way that would uphold the rights of data subjects, protect their data from theft, unauthorized usage, and all that. So the first thing is security measures. Companies that process personal data, instead of saying companies that process personal data, I'm just going to say data processors and controllers now that process personal data have to put in some security measures in place. We're talking about encryption, anonymization of data, restricting access to data based on a need-to-know basis. So if, say, for example, a gateman in the office does not need to have access to customer data, if at all, maybe the data of visitors, but he has no business in being able to access customer data. So access to data should be on a need-to-know basis, also conducting audits at intervals to know, oh, what type of data do we have right now? What are our security system in place? If there is a breach, do we know how we can manage it? Do employees know what to do if things happen? Another consideration is informed consent. So before collecting data processors and controllers must ensure that data subjects have given their consent. That's, they know exactly the purpose for which the data is being collected, how it is going to be used in the event that the purpose for collecting it has been fulfilled. What is the retention policy? So they must know all this and still consent to their data being used. So that's what it means by informed consent. Data minimization too. This means that like processors and controllers must stick to collecting data that is only necessary for the purpose that they are using it for. So say, for example, I want to visit the hospital. Yeah, like an example is that when I visited the hospital, they gave me a form to fill, and then they were asking me for my religion, like either whether I was Christian or Muslim. In my head, I'm like, oh, why do you need my religion to open like an hospital account? It really makes no impact. So like controllers, processors should only stick to collecting data that is necessary to the purpose. Another consideration is cross-border data transfer compliance. So when you are going to be transferring data outside the country, the NDPR as well as the NDPA mentions some things that you should consider: the adequacy decision. Do they have adequate data protection laws? Are they on the whitelist? There are a list of some countries where the NDPC are saying that, oh, they have maybe optimal data protection measures in their countries. So those countries are on the whitelist. So you first have to consider, like, are these countries on the whitelist? If not, have you put in appropriate measures to ensure that the data is going to be safe? Also, have you gotten consent from data subjects to let them know that, oh, this data is not just going to be used in Nigeria, but also outside the contractual clauses for this third parties that you're sending abroad, things like maybe like a third-party processing agreement. So another best practice for data collection and processing is also upholding data subjects' rights. So the NDPA and the NDPR grants data subjects some certain rights. They should be able to access their personal data, to be able to correct it. If you want them to, if you want to withdraw consent, you should be able to do that. If you want to request deletion and all that, you should be able to do that. So your collection, your processing and transfer process must always uphold the fact that customers or data service can always come at any time to access their data. And then DPIAs, so like before you launch a project or a product, or even conduct an event where personal data would be obtained from data subjects, you should first conduct an impact assessment. So like just to see what the consequences, what the risk level is, like what can go wrong with this personal data. If something eventually goes wrong, how can we resolve it and all that? So what the DPIA would do, and then the appointment of a data protection officer. So if you are going to be processing personal data, there should be a data protection officer. So the DPO would work hand in hand with the data protection compliance organization to make sure that the company has the policies in place that are necessary to uphold data subject rights, and not just having those policies in place, but like actual implementation of these policies. Also training employees on data protection, whether on a monthly basis or biannually, but like the data protection officer would be the one to ensure that data is being managed in the appropriate manner. And as an offshoot of what I just spoke about, training staff on data protection, this should also be part of staff onboarding. Let staff know how they can manage client data. If things happen, how can they resolve it? When data subjects come to access their data, how can they undo data subject access requests and all that? So this is why the training for staff should also be part of best practices for a company that process personal data. And so we have different types of data. We have generally, the categories would be personal data or sensitive data, but we also have financial data, children's data, digital data. So your personal data is just as basic as your name, your email address, just something that can identify you, your date of birth. While when we now talk about sensitive data, we're talking about things like your health records, your political opinions, your race, if it's your sexual orientation too. So that is a sensitive data, things that people should ordinarily not just be able to access about you. Then your financial data, we're talking about your BVN, your bank account details, maybe your credit history. Now, if you're somebody who borrows from like a bank, your credit history, your transaction history, also children's data. These are minors based on the Child Rights Act, children for like 18 years and below. Those are minor data about their medical history and all that. Digital data, that's your browsing history, your IP address, that's or any other data, digital data that can identify you. So the levels of data sensitivity, data could just be, it could just be low sensitivity, it could be medium sensitivity, it could be high sensitivity. So from the low sensitivity, these are like information that it is out there, but like you do not need a particular security system to just keep it safe. Maybe like your Instagram username or something. Medium sensitivity. So this means that it is important, and if there is unauthorized access to that information, it could cause you moderate maybe not a lot of harm, but it could also impact you in a way. But high sensitivity on the other hand means that if people that you do not want them to have access to it, it will cause you big maybe your medical history being leaked, your sexual history, sexual orientation, information about your bank details and all that, your PINs and all that. Those are high sensitivity issues. And then for the concept of data minimization, like I briefly mentioned before, so data minimization just says that personal data must just, the obtaining personal data must be adequate, just enough for the purpose that you need it for. If there is no need to take an information, like if an information is not necessary to the reason why you're getting that information, then there's no need to request for it. I use the example of religion to open a hospital account. Like they really do not need that from me. Or if I want to maybe register for an account opening form now, I see that sometimes they ask for social media pages. I don't know if that is part of their KYC, but really, why do you need my social media handle to open a bank account for me? So I don't know. It's debatable. But like if you do not need an information for a product, for a project, then you don't need to just take it for the sake of collection. So less is more under the concept of data minimization. And some examples are for employee information now. When an employee leaves a company, you really do not need some of their information, like their account numbers now, except you are owing them. You don't need to have it in the company database, except if there is a data retention policy that says that, even when employee leaves, maybe you would keep the data for like 1 more year or so. So for another example is online forms now. If I'm going to sign up to a newsletter, really all you need is like my name and my email address. Any other information that is more than this is not observing the principle of data minimization. So the whole concept of data minimization is just to say that restrict the data that you're collecting to what you actually need. Less is more, not just collecting it for the sake of, it's better to just have it than not to have it. No, decide first of all, for this product, for this project, these are the type of data that we need, this because they are necessary for this function, and anything that is outside of this should not be collected. So the whole summary of our presentation is that handling data responsibly is very, very important, especially now that data subjects are more aware of their rights, and the regulators are also very, very proactive in ensuring that data subject rights are being upheld. And also our courts too, over the years, in recent times now, have also been upholding data subjects' rights, as seen in some of the cases in this presentation. So given that, it is very important that companies that process personal data, or organizations generally that process personal data, observe best practices in their collection, in their processing, in the storage, in the transfer, and even after the usage of the data, in the way the data is going to be disposed of. So ultimately, responsible data management is both a legal obligation and a business necessity. We're coming from the angle of preventing penalties or fines from the regulators, and also instilling integrity, where customers know that with you, their data is safe. With you, there's no fear of unauthorized access or theft of their information. So the reward is that you are going to be fulfilling a legal obligation as well as a business necessity. So by adopting best practices, understanding data sensitivity, minimizing data collection, organizations can mitigate risk, safeguard their reputation, and maintain stakeholder trust in their business. Thank you.
Thank you very much, Esther, for that presentation. A very good one. We have group 2. Group 2, are you ready? Group 2?
Yes, yes, we are ready.
Please, you are
Yes, we are ready.
keep to time. Let's hear your presentation.
Okay, I'll share my screen now. Please, can you see my screen? Hello?
Not yet. We can't see it yet.
Oh, I'm trying to share my screen, but I don't know why it's not.
Unless it's just from my end, but I don't think we can see it.
Go ahead and start your presentation. We'll try to share your screen from our end.
So I'm connected to a class, that's why, sorry. Sorry. Hello?
Did you hear? We are saying you should go ahead with the presentation. Share it from our end.
Hello?
Can you hear?
Okay. Okay. Yeah, yes, I can.
So go ahead with the presentation. We share it from our end.
Okay. So good afternoon, everyone. So my name is Laman Abdraman, and I'm presenting on behalf of Group 2. So the topic I'm going to be presenting on is lawful basis for data processing, lawful data transfer, and international data transfer. So under this topic, we are covering 6 key areas. That is lawful basis for data processing, consent and data processing, lawful data transfer, international data transfer, data protection authorities and international cooperation, and finally, consequences of non-compliance. So please, can you hear me?
Yes, we can. Go ahead.
Okay. So in Nigeria, we have 2 main data protection laws, which is Nigeria Data Protection Law, Nigeria Data Protection Act of 2023 and Nigeria Data Protection Regulation of 2019. So under the Nigeria Data Protection Act, we have six means wherein data processing will be classified as being lawful. The first one is consent, which is provided by Section 25, sub 1, paragraph Section 25, subsection 1, paragraph A, which talks about the fact that for lawful data processing to be carried out under the consent basis, the data subject must have given he or she must have given consent, which must be clear, voluntary, and informed. So we have, and this was buttressed in the case of Incorporated Trustees of Digital Rights Lawyers Initiative and others versus Nigerian Identity Management Commission, wherein the court emphasized the need for proper consent before processing biometric data, which in turn means that the consent of the data subject must have been sought before data processing will be carried out. So the next basis for lawful basis for data processing is contract necessity, which states that processing will be lawful wherein it is necessary to perform the contract with the data subject or to take steps at their request before entering into a contract. So here we're talking about the fact that data processing is needed in order to fulfill the obligations of a contract. So here, the example we gave is where a customer provides banking details to a fintech company for loan processing and the company processes the data as part of the contract. However, this is subject to the principle of data or purpose limitation, which means that it is what the agreement or contract that must be. The data processing activity must stick to what is in the contract or agreement. They will not go out of the scope of the data processing activity that was stated in the contract or agreement. Then the next one is legal obligation. This is where the law describes that the data processing must take place, such as the KYC, that know your customer activity that banks carry out for opening of accounts. Then the fourth one is legitimate interest. This is where processing is necessary for carrying out legitimate interest, such as for carrying out the legitimate interest. And in this instance, the consent of the data subject may not have been sought. So here we provided an example, provided a case
for that is paradigm initiative versus National Information Technology Development Agency, which is NIFTA, wherein the course recognized the need to balance business interests with individual data privacy rights. Because if you look at, if we are to say that here, the cost was trying to say that if we are to look at the interest, look at data possession from the side of the data subject alone, that business will not be, that the data controllers will not be able to carry out their business as necessary. Then we have the fifth one is public interest and official authority. This is where data processing needs to be carried out in the interest of the public, such as gave the example of the National Bureau of Statistics processing census data without individual consent for national planning purposes. In this instance, they don't need to get the consent of the data subjects. However, they have to stick to the principle of purpose. They have to stick to data minimization, principle of data minimization too, wherein the only data that is necessary must be collected. You must not collect data that's not necessary for the process for data processing. So the next agenda is determining the appropriate lawful basis for processing. Here we talk about the key criteria which the Nigeria Data Protection Act under Section 26 recognizes as for lawful basis for data processing. Number one is nature of data, nature of the data. That is, organizations must realize that classify whether the data is personal, sensitive, or biometric data. Number two is purpose of processing. They must be able to identify under which lawful basis the data processing they want to carry out falls under. Number three, necessity test. That means they must know whether they must know whether the goal they intend to achieve can be carried out through the data processing they intend to undergo. Then the next is rights of data subject. They must realize when they must be able to recognize whether or not the data processing which they want to carry out infringes on the rights of the data subject. Then the next one, the next slide is on consent and data processing. So the Section 25 of the Nigeria Data Protection Act recognizes some key areas for obtaining consent. Number one, informed consent, which means that data processing will only be lawful wherein the informed consent has been gotten from the data subject. In this instance, the consent must not be vague or ambiguous. The data subject must understand the reason why this data is or data is to be processed and the extent to which it will be processed. Then number two, the right to withdraw. Which means that the data subject must be informed of their right to withdraw their consent at any period of time. They must not be, which means that it must be restricted, and they must not be, they must be given the right to express their right to withdraw. And the third one, minors or incapacity, which means that wherein the data of minors are to be processed, the concept of their legal guardian must be sought before their data will be processed. Then clear communication. Just like I said in the first instance, that the content must be unambiguous and clear. Then the fourth one is specific purpose, which means that the data controller must state the actual reason why they are processing the data involved. Then number four, record keeping, which means that the data controller must keep the records. Data controller must keep accurate records of the data which they process, and also they must keep in a safe and secure manner. We will talk about this safe and secure manner later on in presentation. Then we have another point to note is managing consent withdrawals and revocation. Section 26 of the Nigeria Data Protection Act requires that data subjects must be informed of their right to withdraw consent before granting it. And also, there's now a very key point though, that withdrawal of consent does not affect the data which has been processed, prior data which has been processed, which means that prior data processing activities would not be rendered invalid as at the point, because a data subject requested that the data should not be processed again. Then I'm moving on to lawful data transfer. So under lawful data transfer, we have two segments, which is secure data transfer protocols and lawful data transfer. Under secure data transfer protocols, we have these are the technical safeguards which must be in place for data processing to take place lawfully. Number one is HTTPS, which is the hypertext transfer protocol secure. Which so in essence, this means that the data when data is to be transferred, it must be encrypted to ensure the confidentiality and integrity of the data being transferred. Then the second one is SFTP, which is Secure File Transfer Protocol, which is this is being used secure. SFTP is being used to secure file transfers, provide encryption and authentication mechanisms. Then the third one is pretty good privacy. Pretty good privacy is employed. Pretty good privacy is being used to ensure end-to-end encryption, which ensures data confidentiality and authenticity. An example of pretty good privacy is the end-to-end encryption, which WhatsApp uses to ensure the confidentiality of data being transferred on WhatsApp. Then the fourth and last secure data transfer protocol is IPsec, which is Internet Protocol Security. IPsec is being used to encrypt and authenticate IP packets, thus providing secure transfer. Can you hear me?
Yes, we can.
Hello?
Yes, we can.
Okay. So I've treated the secure data transfer protocol, which are the technical aspects of lawful data transfer. So now I want to treat the legal aspect, so under the legal aspect, we have data transfer agreements, data protection laws, and data subject consent. For data transfer agreements are being used. Data transfer agreements, they establish they lay down and outline the terms and conditions of data transfer, including the purpose, scope, and responsibility of each party. For data transfer agreements, two key things that must be in data transfer agreements are the standard contractual clauses and binding corporate rules. Then the next aspect of data transfer is data protection laws. So for data transfer to be lawful, they must comply with relevant data protection laws and regulations, such as the General Data Protection Regulations and the Nigerian Data Protection Regulations, and also the Nigerian Data Protection Act. Then the last aspect under lawful data transfer is data subject consent. This is very key, and as I've treated under the lawful basis of data processing, data subject consent is the foremost means of getting the foremost means to prove that data processing being carried out is lawful. So under data subject consent, the consent which is being gotten for the data subject for data transfer must be explicit, must be clear and unambiguous. So then the next aspect for lawful data transfer, I'm treating methods of ensuring confidentiality and integrity during data transfer. So under this, we have encryption, digital signatures, secure file transfer protocols, access controls and authentication, data integrity check, data integrity check. Under encryption, encryption serves as hiding and masking the nature of the data being transferred, which means that it will not be clear, it will not be in the clear and original nature. I mean, that you are hiding the identity of the data being transferred in order to make sure that in the midst of in the process of transferring data, it would not be leaked or made accessible to people to persons who are not meant to have access to it. Then we have digital signatures. So for digital signatures, they are like the seals on a royal decree, ensuring the data integrity and authenticity. In today's era, most contracts make use of electronic signatures rather than manual stamps to prevent any fraud. So now, luckily in Nigeria, we have the Cyber Crimes Prohibition Prevention Act of 2015, which was amended in 2024. And under this act, section 17 recognizing the digital signatures as legally binding. So digital signatures have made it easy to identify the veracity of a document as we're in the era of e-commerce, wherein you don't need to meet customers or individuals physically before buying and selling can be done. So in this era now, digital signatures can be used to verify the authenticity of documents and of documents. So the next one is secure file transfer protocols. I've treated secure transfer protocols under lawful data transfer earlier. So in terms of the okay, sorry. Okay, I want to move on to data transfer agreements and contracts. Under data transfer agreements and contracts are formal agreements which outline terms and conditions for transferring personal data or other sensitive information between organizations or countries. So I want to treat the key clauses and provisions for data transfer agreements and contracts. The first is data definition and scope. So under the data transfer, an airtight data transfer agreement will state the data being transferred and the purpose of the transfer. This is very key because where it is not being stated and where the data being transferred is not stated, or the purpose for which it's being transferred is not clear. This data transfer agreements would be declared as being invalid and not sufficient enough for the data as a data transfer agreement. Then we also have data protection obligations. A concise data transfer agreement is meant to state the obligations of each party, that is data controller and the data processor and the data subject. Also, wherein a data processor is involved, they have to state the obligations of data processor also. And it also has to state the confidentiality, security, and compliance mechanisms which are in place for the data to be secured. And this has to be in line with data protection regulations. The next is data subject rights, which a concise data protection, a concise data transfer agreement must state the rights of the rights of the data subjects, such as access, correction, and deletion. Then the next is data breach notification. A concise data protection, a concise data transfer agreement is meant to state the mechanism, the notification which will be given to the data subject wherein their data is being leaked or breached. Then the next is liability and indemnification. This states that the liability and indemnification for data protection breaches or non-compliance must be clearly stated in the data transfer agreement. So in preparing our slides, we highlighted cases wherein data controllers who did not take appropriate measures were fined by data protection authorities. The first is Schrems versus Facebook Ireland, which is a 2020 case. In this case, the European Court of Justice ruled that Facebook's data transfer mechanisms were invalid, and they highlighted the need for robust data transfer agreements in order to ensure data protection compliance. The second is Microsoft versus the US government, which is 2016. In this case, Microsoft challenged the US government for requesting to access customer data stored in Ireland, and hearing emphasizing the need for data transfer agreements to clarify data transfer obligations. The third is Google versus French Data Protection Authority, which is a 2020 case, which was decided in 2020. In this case, Google was fined 50 million for violating the GDPR, which is the General Data Protection Regulation. In this case, the court highlighted the importance of data transfer agreements in ensuring compliance with data protection regulations. Another case is the case of Chukwuemeka Akosa versus Jumia Foods and Eat and Go Limited. This was a case decided last month, which is February 2025. In this particular case, the court fined Eat and Go Limited 3 million naira for sending unsolicited messages to a plaintiff, even after he had written to them to stop processing his data. Another case is the case of Olumide Bawala versus Edmond Solutions Company Limited. In this particular case, the court fined Edmond Solutions Limited 2 million naira. This case was decided on December 12, 2025 by the High Court of Lagos State, Ikeja. So in this particular case, the court fined the Edmond Solutions Company Limited 2 million naira for sending messages to the claimant, which is Olumide Bawala, all because his number was listed as a contact of a debtor to the loan company. So in conclusion, I want to state the roles of I want to state the challenges. In conclusion, I want to state the consequences of non-compliance with data protection laws and regulations. The first is fines, which Section 48 of the Nigerian Data Protection Act provides for the fines which can be levied against a data controller who refuses to comply with the provisions of data protection laws and regulations. The first is higher maximum amount, which is to the sum of 10 million naira or 2% of the annual gross revenue, whichever is greater, applicable to data controllers or processors of major reporters. The second is standard minimum amount, which is 2 million naira or 2% of annual gross revenue, or whichever is greater, applicable to smaller data controllers or processors. Then the third is that the data controller or processor who refuses to comply with data protection laws can be sued by the data subject whose right were breached. Then number 4 is that it can lead that non-compliance with data protection regulations can lead to lack of trust by the customers of the data protection of the data controller, which would lead to loss in revenue and business. So, with this, I want to end the presentation. Thank you very much. Hello.
Hello. Okay, guys, I was muted. Thank you so much for that presentation and for being so detailed. While our mentees were presenting, one of our mentors came on board, Mrs. Jedi. Is she still?
I said with this, hello.
Yes. Hello, Mr. Suleiman. We heard you. Yeah, well done. Thank you for your presentation. Please, moderator, you can go ahead.
Okay, so while he was presenting, one of our mentors joined us and would love her to come take the stage and give us her own. This would be a combined session of a feedback and the mentor's presentation. So, Mrs. Jade, forgive me if I'm mispronouncing the name, but I'll do better next.
It's okay. Good evening, everyone. My name is Jade. It's nice to be here again. So I went through the presentation and I was really to, I rushed through actually. So forgive me if I give a feedback that it's probably because I had missed out on something. But I tried to go through those presentations and I was jumping in and out of the presentations. But very well done, very well done. I like the aesthetic, for lack of a better word, of this like it made me want to read more of what you guys are presented, and because it was clear, I was able to go through it at a glance. So first thing I want to go through, I would like to applaud the number of patients that you have been sent to. One of the feedbacks that was that the last one, the training ago, was on not using case laws, and I can see the difference here. I'm not sure I saw any in group one. If it was there and I missed it, well, but if it wasn't there, this is something that I would like to push for group one. I'm not sure that I saw it, right? But it is important that it is easy to read the law. Anybody can pick up a book or do research, especially in these days of ChatGPT. It's so easy to come by information. But reading case laws and everything helps you to understand the application of what you have read. And I like the fact that Group 2 had not just Nigeria, there were foreign cases, and then they had cases that also, pertained to Nigeria. So kudos on that. So I would like to, start by, let me do my intro. Like you said, this is a two-in-one approach. I'm making my comments on the presentation and then doing my introductory remarks. Please confirm you can hear me.
Yes, we can, ma'am.
Okay. All right. So the reason why I like joining the training is because most of the people I notice that some people it is good to have a balance of all the people involved in data protection. And so you have the data subject, you have the data controllers slash data processors, you have lawyers who are trying to enforce the provision of the act, and we have the regulators. Anytime you are doing a presentation, it is important that you wear all these caps so that you are able to see where each of these persons are coming from. And I think I noticed that in Group 1's presentation. Now, there are certain questions that came to my mind during the presentation. I think it was Group 1 who had mentioned the cause of data minimization, that you are not sure why somebody needs to, an hospital wants to collect images. So what happens in the case of Christian who is over business, and they are the ones that don't allow blood transfusion, right? What is that what they are able to determine? Or when you are saying that if you want to open an account, and I can't remember what the person said. I wish I can remember, and I had made the comment, so I can't remember where I made it. So the crux of what I want to say is something that both groups had said in their presentation was about DPIA. The DPIA is like the crux of all the things that we are discussing today. When you are conducting a DPIA, please confirm you can hear me. Hello, can anyone hear me?
Yes, I can hear you.
Okay. All right. So once you are able to conduct a DPIA, then you are able to address all the points that comes up in all your presentations. In the course of DPIA, you are able to determine why are we collecting this data. You are able to determine the purpose. then when you know the reason why you are collecting the data, then you know the amount of data you want to collect because there is a goal, right? There are certain things that you need to do to get to that goal. So for instance now, we are getting the information on the account opening form for let's say three purposes. We need to be able to conduct this is for financial services. So I will use like different institutions. For financial services, the client will open an account, this the person the account opening form. Now the information that you want to collect from the account opening form, you need it so that you can conduct your due diligence. You need it so that you can file your regulatory returns to the CBN, to the SEC, the NSIE, the SCOMO, depending on the sector that the person is. Now, all this determines, and then you also need it for marketing because, like it or not, your data is almost not useful to a data processor or a business when they are unable to push their marketing products. So it is also part of the reasons why we are collecting it. So I'll make sure that all this information that I'm collecting, they are able to help me achieve the goals that I'm trying to reach. Now I need to cover myself to get this information that I'm asking you for. So I make sure I have something like I am able to get your content, I am able to put it on that contract. Okay, because I'm hiring this type of services, I have the legal obligation to collect the data, or it is just what is expected when I'm running this kind of business. So it is like legitimate because I need you to be able to properly serve you. When you conduct a GPI, what I'm trying to say is that it helps you to pick all these gaps. So GPI is actually like one of the most important elements in data protection. And the thing about the GPI that you conduct is that it has to be risk-based. So you are not only thinking about covering your track when it comes to regulatory compliance or trying to do legal justice so that if anybody asks you a question, you are able to answer. But because you are honestly trying to protect the people, and that's the case of risk-based CCIA. So you are considering the risk that can happen in the process of collecting this data. The first thing is to identify the risk. Once you are able to identify, once we collect too much information, it means that breach becomes more because you now have more information. You need more resources to keep it. All those things will help you to shape how you go about collecting the information and processing it. I hope you understand what I'm trying to say. And it also helps you to know the kind of security measures that you want to put in place. So for instance, it's so difficult to keep what you call physical copy forms, in between transferring, getting approvals, using from one place to the other, you can get lost, you can water can touch you, all those things are there, and then we switch to electronic. Now we are doing electronic account opening. We have fintech, we have apps, we have all sorts of things now that enable us to open accounts on the go for whatever services. Or we need to put cyber security systems in place so that we are able to protect all these data. What are the things that we want to collect? So what ties all the things that everyone has spoken about today together is the concept of GPIA, and not GPIA for window dressing, or a risk-based GPIA with the consciousness of identifying the risks involved in all of this, how we can mitigate it, and how we can protect ourselves against it. So I wanted to tie all that into together and without repeating all the things that other people have said. And I think it was this one when they were talking about transfer of data. That is particularly to data portability, and that is that we keep data in such a way that it is easy for you to transmit, it's easy for you to transfer, right? And I noticed that this one had focused primarily on cross-border transfer, forgetting the fact that we also have, movement of data within the organization, between the data processor and the data controller, between states in Nigeria, before we now even start, going outside the country. And so, one of the fights that I always have with my people in-house is they want to make a presentation and I'm seeing ABC and I see the impressive portfolio, and they are honestly doing their job, is what they are supposed to do. But because it's not everybody on that table that needs all the information that they are sharing, right? Is it not better to anonymize the data? That's a form of data security, that in the course of we are transmitting the data from one department to the other. But I realize that the information that customer service needs is not the same information that let's say operations needs. So how about I only give them the extent of the information they need, so that a client's business is not just all over the table. Do you understand what I'm saying? And so that's why I was happy to see that Group 2 expounded more on, the security measures that you can have for data in the course of transferring data and all sorts. And you would see that if we actually keep in mind the principles of data security, there'll be less chances of a breach. And it's honestly because people do not pay, right? If you understand what I mean, you just see, you go to, let's say, a hospital, for instance, and then they have a hard copy file. And on the hard copy file, you can see the full name of the patient. And you can even see the department that is in charge of. So when you see something like oncology, you know that this person is dealing with cancer. But how about we just have a code for the patient's name on the face of the file, so that even if somebody comes across the file, he is unable to determine who that person is. So I don't know if you understand. So I would have loved to see, when you were talking about best practices for transfer of data, I would have loved to see it segmented into, data within the same institution, data within Nigeria, and data outside Nigeria. But all in all, good attempt. And like I said, I don't want to, reiterate what both teams are talking about, but just to shed more light on things that I think, were not touched on, or things that could have been done better. So let me stop here, and then I'll wait for Q&A to add more points. Thank you.
Thank you so much, ma'am, for making this session even more enriching. We're grateful for your presence and for your lecture, what you've shared with us. And we just found that Mr. Ridwan has joined us, and we will proceed to take his part next. But before that, we are going to have a picture time. It's our picture time. So I will ask all of us to okay, no, don't. I'll ask all of us to open our video, show your beautiful faces, and screenshots. Thank you. I can see you, Glory. I can see you, Suleiman. What about others? Yes, please. Turn on the video. Then capture the moment, take a screenshot. Share it on your social media handles, but after the session. I'm going to give 1 more minute. And put on your best smile. I'm seeing frowning faces.
Okay,
Please
so we are
smile. Okay.
done with the pictures. Thank you.
All right. So next is Mr. Ridwan. You have the floor.
Hello, everyone. Good evening. I hope you can hear me. I'm on the
Yes, we can.
move, so it might not be very clear. So I actually don't have a lot of things to say. I have a couple of comments, and the first one would even be, acknowledging what my colleague Jaroslav have said. I mean, I think I've covered the field. Yeah, done a lot of justice. I mean, for the topic. And that's even aside the presentation I was opportunity to listen to. I think that was when I got in. when group two was just about to start their presentation. So it was really great because I'll say enlightening as well. I liked the way it was. I didn't have the opportunity to hear the one speak, but then I was able to go through the presentation as well. So great work as well. But what I like about group two, I quickly glanced through their. I think when they were speaking, I quickly glanced through their presentation as well. And I see. I mean, the reason I really like this, and the reason this was very interesting is because they really covered almost everything, even those things that ordinarily you won't find in a lot of articles, in a lot of materials online. What I mean by that is, or even if you would find this, but they really do great, bringing a lot of things together, even things that you won't really expect. Probably you have less around there as well that or maybe some of you have experience, hands-on experience already. I mean, probably during all this or advising, maybe you've worked with some consulting firms that advising companies, regarding data protection. So it was really insightful. You really did great. And so that's my comment. I don't really have anything to add. I think the other thing I wanted to mention, probably you have different scope of work. I didn't really see the legal business or the lawful business in group one's presentation initiatives. I wanted to mention that until I saw it in Dixon's um, presentation. So it's good that you're able to cover everything, and it's good that you're able to cover a lot of. I mean, when we're talking about best practices as well, you should. I think that's another thing I just kind of observed. If you're talking about best practices, some of those best practices that you listed could actually be they are not just best practices. You should have in mind that many of them that you've actually highlighted as best practices are requirements. They are requirements. Like you have to comply with these provisions of law. So, but the thing is just that I was saying the other day that all these all these requirements are kind of intertwined. So when you're speaking about data protection principles, there's no way when you're talking about lawfulness, you need to go back to lawful basis. There's no way you're going to be talking about proposed limitations somehow that you need to go back to data subject rights. So they are all kind of intertwined, and it's until you start working with companies, you start seeing how it's been done in the field. That's when you really understand what's real at stake. Okay, so great work. So I said I wouldn't say more. I'm just somewhere because I have some issues on my way home. So the other thing I have, so I won't say much because that is what I said a lot. That's a very very relevant. And as I said, I think she has covered the whole field already. So the other thing I just want to say is because I was really impressed. So I was thinking of how I can because I from yesterday to today I mean there were a lot of meetings I was attending with some of our clients who wants to file their data protection because today is the deadline, even though we have the habits of the regulator, postponing the days. I haven't seen anything yet, so or maybe there's something that I haven't just seen. I mean, regarding if it will be postponed or if it has been postponed. But there's a lot of things, there's a lot of all these things to file. I think I have four that I have to file as soon as I get home. So, um, so I was thinking that what's the best way to kind of give back or to kind of show that I appreciate what you've done, and I was thinking that maybe we could, and that's another way we could also kind of appreciate what Gypsy is doing. I don't know if you pronounce that it was JIIPCC. So what they're doing as well, they exposing to networks of professionals like Java Selection. She's my senior. Just kidding. So, so, so I'm thinking of, you know, it was like extending a kind of proposition to, I mean, wherever I'm interested, especially from groups. So maybe I'll take two. We'll take two from groups and one from group four. Something like a research assistant, maybe for at least for 3 months. It could go beyond that, but at least for 3 months to kind of see, to kind of work with us and see how things are being done. So what I'm saying essentially is to make it clear is that extending the proposition to to get like 3 research assistants. So it's not going to be big. So that is just for you to get experience. So it's not like you have money, but at least it's going to be at least you have some kind of piece of uh, emolument, a bit of that. So don't think it's going to be. I'm not. I mean, if you want big money, you can go to Jaritola or you can go to Ridwan. You know, you should know Ridwan. Oluyide. Those are our the money fast, in the industry. So
I don't know
um,
what you are talking about.
you know what I know. So I don't know. Maybe I'll reach out to Dennis or Sophie and maybe share a form for those that are interested. And then I'm sorry I can't. I mean, if I had that capacity, I would really be willing, and I would be really happy to take everybody in. And but I think for now we should be able to take 3 persons. So I really look forward to your growth in the field. I mean all of you. So that's it. If you would allow me to take my leave now. So I'll connect to see you later, Jennifer. Thank you for everything you did. Okay, bye everyone.
Thank you so much, Mr. Reedwan, for that very insightful presentation and comments. And if you look at the chat box, you see our mentees are really looking forward to this opportunity and would want to put their best foot forward. I apologize. I have to turn off my video because it's dark and there's no light where I am. So the next agenda we have is question and answer session. So I know we're burning with questions, and for enthusiasts like us, there are probably one or two things that we do not fully understand or we want clearer insights on. So this is a very good opportunity. You can ask it as a question in the chat box. I'll take it up from there, and our mentors will also see it there. But if you wish, you can also unmute yourself to ask. Okay, our first question is here, and it is, okay, I'm going to ask these 3 questions and then keep it open, hanging on the floor. What are the 6 lawful bases for processing personal data under the GDPR, and in what scenario are they typically applied? The second question is this: how can organizations ensure lawful data transfer when sharing personal data with third-party vendors or service providers? The third question: what mechanisms can organizations use to facilitate lawful international data transfer? It's an open question. I don't know if we still have our mentors on the call. Please, can you
So I'm here. So the first question, I was tempted to say research, but let me just answer. I mean, you already know the place to check for it, but let's just answer. Um, so the person wants to know. Oh, it's not somebody. It's from Gypsy. Oh, sorry, apologies. Are you asking the mentors or the mentees?
It's the question sent from the mentees. It's them that sent in the question. I think this was group two's question, if I'm not mistaken.
Okay. All right. So I'll answer. Okay, and in what scenarios are they typically applied? Okay, so I'll just state the lawful basis, and I hope memory serves me right and I don't leave out any. So we have consent, contract, compliance with legal obligation, vital interest, public interest, and legitimate interest. So I'll just do a quick summary. consent. We've spoken about, I think it was mentioned in somebody's presentation, the principle of consent, right? You must obtain consent to process data, and the consent must be clear, unambiguous. They must know what they are consent. The data subject must know what they are consenting to, and consent is particularly important, more therefore important in the case of a minor, because ordinarily minors cannot give consent. So it's a very important, you know, aspect of lawful basis. I always like to pay particular attention to it. It must be freely given, unambiguous. Uh, you know, you can do more research on that. And we also have performance of the contract. So both of us enter into a contract to um what can I say now? Okay, so I have gone to meet a law firm, for instance, for them to help me register a trademark, right? And without a given, or it is expected that the information about the company, the logo, okay, let me use CAC registration that everybody is even familiar with. I have approached somebody to help me register a company, right? That's the extent of the contract between us. For me to be able to pursue the object of that contract, then it is expected that I'm going to give some of your information to CAC. That's the only way I can provide the service that you have asked to be rendered to you. So even if it is not clearly stated in the agreement, in pursuit of that contract, it is expected that I have to take those steps to be able to fulfill the subject of the contract. Then we have vital interest. So vital interest basically is the best way to put it is life or death situation, preservation of life. So let's say for instance you have got somebody had an accident or something, and you have information about the person's health status that can save the person's life. There and then, if you say anything about it, it will not be considered a breach because you are trying to save the person's life, right? Uh-huh. And public interest. So this is when you are processing data for the interest of the public. This is a very important aspect in health law. In fact, I did a research, for my thesis, my final year thesis on the concept of privacy and confidentiality in health in the medical profession, and you would find that it's always a state of dilemma, or almost always a state of dilemma, trying to protect one person's privacy at the expense of the general public. So, for instance, you know that somebody has, let's use HIV status, for instance. You know somebody's HIV status, right? You're expected to keep it confidential if one of their sensitive, data. But you can see that this person is very uncaring, sharing needles anyhow, exposing himself to multiple sexual partners without protection, and all the things that can, spread the virus. If you make person's status known in such a case, then it will not be considered as this because you have saved the general public. If he goes around sharing the disease, before we know what is happening, we have a pandemic. I don't know if pandemic is the right word, but I trust that you understand what I'm trying to say. So when it has to do with public safety, public health, etc., that's when you have what's it called? Public interest. Have I missed out on anyone? Aha, legitimate interest. That's like the umbrella that before I go to legitimate interest, let me just speak about legal obligation. So I had spoken about it in my presentation that as a financial institution, for instance, you have the obligation of reporting to your regulators. So if, for instance, the person has this example can I okay now the Money Laundering Act provides that if one individual makes a transaction of 5 million and above, then you need to report it. So if you report such a transaction, which would typically include the person's name, the person's bank information, and all this stuff, if you report to the regulator, then you are under a legal duty to do so. Or let's say that you have been called as a witness in a matter in court for you to provide certain information, you are under oath, you have to provide such information. So now going to legitimate interest. Legitimate interest is like the umbrella that everybody tries to hide under. So this is when you are processing data, for to achieve a lawful purpose, to achieve, how do I explain it now? You have a legitimate interest when it is not, you are doing it for the benefit of both the data processor and the data subject, not necessarily that it's going to, affect the the data subject. So for instance now, let's say Jumia. So Jumia has your purchase history and other stuff on their website, and they know what your pattern is. They know what your usual, what you would typically buy and all sorts. If they notice a movement on your account that is different from your regular movement, then they can, explore all the data that they have to try to see whether you are actually the one that is using your account to shop with them at that particular time. I hope you understand what I'm trying to say. So how to know that you are under legitimate interest is for you to do, there is the purpose test and the balance test. I think there are three. I can't remember the third one. So the purpose test is you want to know the reason why you are processing this data, in whose interest it is it. If the data processor will typically benefit from it more than the data subject, then there is a high unlikely chance that this is going to cover you. Okay, I think that's all about that. Am I answering number 2 and number 3 too?
Yes, ma, please go ahead.
Okay, number 2, how can organizations ensure lawful data transfer when sharing personal data with third-party vendors or service providers? I mean, I will not overflow this. Your presentations had spoken largely about it, but the primary things I will just speak to is, so when you are engaging a third-party vendor, you want to do some form of due diligence on the vendor. You want to know what their practice is, how do they handle data, what's their track record, and the people that they have in their business knowledgeable about data protection. You don't want to commit the data of your clients or of the data subjects that you have with you to people that would handle it illegally. Then aside from that, you now do a contract. You execute a contract with the person so that you can, if anything happens to, in this case, the third party vendor would be a data processor, right? So if there's a breach or whatever in a scenario like this, the data subject will not hold the data processor liable. It is the shirt of the data controller they will hold. So the data controller, you first attend to your data subjects and do all the things that you do. Then after that, you now come and meet your data processor. And the easiest way for you to chase after them is if you have a contract in place and the contract specifically has a data privacy clause, then you can use it to chase after them. So I think I've answered that. The third one, what mechanisms can organizations use to facilitate lawful international data transfers? I mean, there is no point speaking into this. We've already, discussed it I think, in my presentation and in the presentation of both groups. So even when data is at rest, it is important that you keep it secured, whether by anonymization, encryption, or whatever you have. And there is also the cyber security bit where you put in all the necessary. I don't have all the technical words now, but you put in all the necessary encryptment and encryptment and encoding words and all that. I think it's primarily contained in group 2's presentation, right? And one of the things that you can do for transfer, your primary responsibility is to make sure that you verify um what data laws they have in the receiving country. Once it is coming out of Nigeria, you want to know what data law that you have. And then it is important that, if it is not something that you are doing based on legal obligation or vital interest or what have you. You must get the data subject consent, especially when you are transmitting such data to a receiving country where they do not have data protection laws. It is very important, and you let them know the risk that is involved. Oh, you have asked us to transfer your data to Cambodia. I don't know if Cambodia does not have, I'm just saying, you have access to transfer. Do you know that they do not have? Do you know that they could be able? Do you know that they can sell your data? Oh, go ahead. I need you to send it to them. Blah, 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 blah. So you have to do that. An example of that would be, what can you have that they ask from us? Sometimes they ask us, your data subject can ask that you write to maybe an embassy or a country or something, just letting them know their financial position with you. So you want to tell them, oh, we are going to be exposing your portfolio to this country. Do you know that this is what we know about them? They don't have data laws. They can sell your data. They will profile you. Once you get into that place, you have people start to approach you for X, Y, Z. And people say, oh, no, I don't mind. I need them to have this information. That's good. Instead of calling them, you can as well do an indemnity letter, and send to them so that once they sign off, whatever happens, they've already sort of given their consent to it. All right. We have how do we handle situations where consent is withdrawn after data has already been collected and processed? So it is the extent when the consent is withdrawn that you're processing the data in. So which example can I use now? I don't want to use regulated space because regulated spaces, banks, insurance companies, um, pension administrators, trustees, even legal practitioners to a large extent, they have laws guarding how long they should hold on to data. But in other cases, let me use for instance, all these research companies and other companies that send you marketing emails, right? Then they always have the option for unsubscribe. When you click unsubscribe, to a large extent, it means you have withdrawn your consent from them processing your data to the extent of sending you marketing materials. Now, the ones that they are sent to you in the past, they have already so processed the data, right? So what happens is what happens going forward? I think there was a recent case like that. So, I can't remember the case. I can't remember the case now. The data subject I think did it involve a bank? I can't remember. I'd been getting marketing emails from the data controller, and he had unsubscribed, written messages that I don't want. I think it had to do with a bank because they were also they were taking charges from him for the text messages, and he had opted out several times, but they kept sending him things, and it took them to court and won because he had withdrawn his consent, but you were still processing data. Do you understand? Now, what should data subjects do when they are not given a genuine choice to consent, but are trapped in a take it or leave it kind of policy? Now, that's the type of consent that is frowned upon. If you remember what we said about, what consent must not be ambiguous, it must be freely given. Very important. It's important that consent is freely given. But I think I understand the situation. It is either you accept this thing or you are unable to use our service. But in the real sense of it, there is really nothing anybody can do about this. Is the service I want to offer to you. And these are the things that I will want to do with your data. I have to do with it. If you are going to do business with me, this is what I want to do with your data. Take it or leave it. You cannot force a business owner on how you want them to handle. They are different unless maybe it is a business where it is just one single entity or maybe limited entity licensed by the government to do that service. But if it is a service that more than one person, you cannot force a business on. It's either you agree to my terms or you don't do business with me. Where the problem will be is if the data controller is not transparent in their terms. You don't know that. But if they said it clearly, this is what we are going to do. Do you agree or not? If you don't agree, go. Not by force. It's the same way you cannot force an unwilling employer on a you cannot force an unwilling employee on an employer. In the same way, you cannot force a data subject or a client on, so I'm not doing it, I'm not doing it. I don't know if you understand what I'm saying. So I've been hearing my voice too much, but I think I've attended to all the questions.
Yes, ma'am, you have. Thank you so much. Somebody's hand was raised up. Was it Nduhwe? I don't know if you have a question, but
Yes.
I want to clarify. Okay, please go ahead and ask your question.
All right. Good evening, everyone. So, Mrs. Jade, my question
Please,
is,
actually, but go ahead.
all right. Okay. So my question is, in the case of capacity, not having the legal capacity to consent to give your consent, right? Now, when
Mm-hmm.
this is done, like in the cases of social media, when maybe children or people that are mentally unstable give their consent, does the law still apply for like to like social medias, or is this still just related to or is this still just related to this thing or is this still related to or is it only related to face-to-face transactions? Does it apply to social medias? That's in the case of not having the legal capacity to consent.
Okay, so thank you. The social media is still something that everybody is struggling to regulate. As much as possible, the owners of the platforms, Facebook, Instagram, and all that, they have their privacy policies, and stuff that they have put in place to try to regulate the space. But it is a space that is quite difficult to regulate in the sense that, everybody has come together. I don't know if you understand what I mean. And to a large extent, the people that can regulate it are the owners of the platform, which is what they are trying to do. You would notice that, okay, let me first put that down first. Second, there are some people that lack the capacity to give consent. So it means that they cannot give consent. Minors, people that are mentally unstable, somebody that is in their drunken state, those people cannot they cannot give consent at all. So you cannot say that maybe they are grant or the type of consent they give or what. They don't have the ability to to give consent, and that's why those people have guardians. Do you understand what I'm saying? Now you would find that in some cases, if you speak to people that have social media platforms, YouTube, Facebook, or whatever, they demonetize videos. Sometimes they demonetize videos, demonetize posts, that has to do with a child. And why they have done that is because so that the motivation for people will not have money as their motivation of you know, um, putting their children online so that they are able to get more followers. They even sometimes they deactivate some people's accounts, suspend them, and when they appeal, they tell them the reason why, and you will find that these are part of the reasons. These are the things that the owners of those social media platforms can do to kind of regulate the space. Right. So it is a menace that I fear that is going to get worse in the future. You see all sorts of things that people are doing with their children. And I believe that it is something that, policymakers and regulators are looking to enforce. But what we have so far are just some of the measures that the owners of those platforms have put in place.
Thank you for that question, ma'am. Ijom, I hope that answers your question.
Yes, thank you very much.
Okay. And do we have any other question on the floor? In the absence of any other question, we've come to the end of our session today. I'm grateful to everyone that made out time to attend, and was active from the beginning of this session to the very end, particularly to our mentees for their active participation, and also to our mentors for being able to share their rich experience with us, their professional expertise. Thank you, everyone. And please remember to share to your social media platforms. Spread the gospel of JIIPCC. Tell a friend to tell a friend. So, oh, I just opened the Mr. Solomon. Welcome. You have just the most perfect timing. Just
Thank
as we're about to
apologies.
conclude.
I'd actually been around for some minutes, 20 minutes or thereabout. And of course, I sent my that I'll join in late. I'm so sorry about that. I was caught up with some emergencies.
Okay, it's understandable. We know how busy you can be. Thank you for still making out time to
By the
come.
way,
I don't,
as
do
a
you
matter
still
of comment, I think I actually saw that mentees took the hint of the mentors last week to incorporate decided authorities in their presentation. I think that's quite commendable.
Thank you, sir. I was wondering if you still want to say any other thing with regard to since you said you've been around for almost 20 minutes, if you still want to address the mentees.
Oh, well, I think, quite frankly, the last 20 minutes have been quite warm for me, warm in the sense that as the mentees were asking questions, our mentors also, of course, have been quite responsive to them. But generally, you know, the good thing with an emerging field, you know, like data protection, is the fact that we will always get to learn better when we, one, can imagine possible circumstances of violation of our right to personal data. And of course, we can do more by actually putting our newly acquired knowledge into immediate use. This is what I'll be saying to our mentees from this moment. If you are in school or you just newly graduated from your law program, I'm sure you have around you friends who run fashion blogs, new blogs, and all of that. Some of them run these blogs without privacy policy. Now, some of them even have functional website without privacy policy. So one of the best things you can do is to even start by contacting your friend and say, hey, can I do this for you? Okay, you know what? Just pay me anything. Or if you don't have any more amounts, don't worry. Now, you and I will know that you owe me. Now, why am I saying this? I can tell you categorically that if all you keep doing is to keep learning without putting it to immediate use, you will forever remain an enthusiast. And that's a fact. Now, so, because you see, learning alone does not make you an expert until you put what you have learned to use, immediate use. So you don't have to wait till you get a bill brief or you have to go into the country particularly because you're not called yet. But find opportunity to put what you have just learned to immediate use. By that, you even learn better because you don't learn more with mentors just sharing with you until you are confronted with real life situations and you are able to creatively offer a solution. So my challenge to you, go out there, solve a real life problem, and of course you will learn better. Thank you.
Thank you, sir, Mr. Solomon, for that. I mean, I've been a learner for all my life, for most of my life, and I know why. So I'm going to practicalize more often. So now we've come to the final, and I've said that before. So now we've come to the end, the real end this time, the end of our session, and I'm grateful to everyone for even spending these extra minutes that we. Is there a question I'm seeing? what if people don't want this to end? What if you're not a lawyer? How do I practice? Mr. Solomon, I think this question is for you.
Yes. So this question, when you look at it, data protection experts or consultants do not, or even trainers do not even have to be lawyers alone. I can tell you, and all of you can see it, that when you check the website of the NDPC, you will see that people who can be licensed to practice as data protection experts are lawyers, accountants, auditors, or even maybe ICT experts. The most important thing is that if you can give your heart to learning the rudiment of it, of course, you have resident knowledge, whether as a lawyer, you have knowledge of rights, if as an ICT expert, you have knowledge of the functionality of technology, and as auditors, accountants, you have knowledge of audit and review. So you do not need to be a lawyer to work well as an expert on data protection. Maybe this will actually challenge some people's stereotype knowledge. I got a friend who is a consultant with the World Bank and Asian Development Bank. When this guy discusses human rights, most non-human rights lawyers will have to sit down and start asking him questions. Guess what? This guy studied theater arts. But over the last 10 years of his career, he has actually practiced as an ESG consultant to the World Bank and to most multilateral institutions. He has done this repeatedly and he has gained, renowned expertise in it. So my point, you don't have to be a lawyer or even a law student to work as an expert on data protection. Give your heart to learning. And if you need to practice as a consultant and to register with the Data Protection Authority, which is NDPC, in the case of Nigeria, of course, they will tell you, okay, these are the qualifications you need and all of that. So I don't think it's for the exclusive preserve of lawyers. No.
Okay, thank you again, Mr. Solomon, for answering that and answering it very right. Any other question has to be forwarded to the JIIPCC group, and we'll send it off to our mentors to answer and then give you feedback. But I hope this is the final end. I'm grateful again to everyone for staying out to this end, and enjoy the rest of your evening.
Do have a great weekend ahead.